Imagine you are a lawyer, and your client sits down in your office and just casually confesses to a massive multi-million-dollar financial fraud.
Oh, wow.
Right. And the police are completely clueless. The public is entirely oblivious, and people's life savings are essentially evaporating as we speak. Now, as an officer of the court, you can just pick up the phone and warn someone, right?
You would think so, yeah.
But the answer, shockingly, is no. You are legally bound to stay totally silent.
It goes against literally every human instinct we have about justice. I mean, it really does.
It totally does.
But in the legal profession, a lawyer's silence is the very foundation that the entire justice system is built upon.
Welcome to this deep dive. Today, we are pulling apart the invisible architecture of the legal profession. Our sources come from the Legal Debrief series, specifically their materials covering ethics and professional conduct for the SQE1.
Which is the solicitor's qualifying examination.
Exactly. Now, whether you are actively studying for a law exam or you're just someone who, might need a solicitor one day, understanding these rules reveals exactly what you have a right to expect from your legal representation.
It's vital stuff.
It is. Our mission today is to answer one massive question for you. Can clients truly trust solicitors with their information and their legal affairs? Okay, let's unpack this.
Well, these sources are fascinating because they aren't just dry textbook rules for you to memorize.
Right.
They are actually a blueprint for how professional trust is artificially engineered in society. Like, if the public doesn't believe their secrets are completely safe, the justice system just grinds to a halt.
Because nobody would talk to their lawyer.
Exactly. People would simply stop seeking legal help, which, leads to vigilantism and just utter chaos.
So let's look at the bedrock of that trust, which is confidentiality. The rule from our sources is incredibly broad.
Very broad, yeah.
Essentially, if information is confidential and it relates to a client's affairs, a solicitor must assume they simply cannot disclose it. It goes into a metaphorical vault. But, I have a hard time believing this is absolute.
Oh, it is remarkably strict.
But I'm picturing the timeline of a case here. Once a trial is completely finished and it's in the public record, or let's say the client actually passes away, surely that vault unlocks.
What's fascinating here is that you would think so, but the vault effectively never opens just because time has passed. Confidentiality survives the end of the retainer.
And by retainer, we just mean the formal agreement where you actually hire the lawyer, right?
Correct. When that contract ends, the duty of confidentiality absolutely does not. You don't get to just write a tell-all memoir because a case closed 10 years ago.
Yeah.
And more surprisingly, it even survives the death of the client.
Wait, really?
Yes.
The secret actually outlives the person who told it.
It does. The sources give a very clear scenario of this involving wills. Suppose a solicitor drafts a will for a client, and a family member who is a beneficiary calls up the solicitor. They just want a tiny hint about what is in that drafted will before the client dies.
Just a little sneak peek.
Exactly. But the solicitor cannot tell them a single thing. The duty of confidentiality still applies. You cannot give someone a sneak peek at their inheritance because that information belongs exclusively to the client.
Even if the client is just quietly living out their final days in a care home.
Even then, the vault stays shut.
That is a remarkable level of lockdown. But let's be real about how these secrets actually get out. When people think of a breach of confidentiality, they usually imagine like a hacked server or a stolen briefcase.
Right, the cinematic stuff, a whistleblower going to the press.
Yeah, exactly. But the reality is painfully mundane, isn't it?
It is almost never espionage. It is human error.
Our sources specifically highlight an exam tip that brings this right down to earth. The accidental breach. So imagine a receptionist at a law firm leaves confidential client information visible on their computer screen while visitors are waiting in the reception area.
Happens all the time.
And someone just glances over, reads it, and that's it. That is a breach. Nobody intended it. But if a temp worker leaves a screen on, is the senior partner really on the hook for that?
They absolutely are. And this shows us how the ethical architecture actually functions in practice.
How so?
Well, the firm's responsibility includes all support staff. Good intentions do not matter if the information gets out. To prevent this, firms can't just rely on lawyers having good morals.
They need actual systems.
Right. They have to engineer physical and digital safety nets. We're talking privacy screens on monitors, automatic computer logouts, rigorous training for every single person who steps foot in the office.
From the senior partner down to the weekend cleaning crew.
Exactly. The entire firm is the entity of trust.
But if the boundaries are this absolute and, Confidentiality survives death and covers everyone in the building. It creates a massive amount of friction. I am picturing a total nightmare scenario here.
Lay it on me.
What if my client tells me they are on their way to physically harm a witness? You're telling me I just have to sit there and let it happen because of confidentiality?
No. And this is where the strict rules crash into human reality. There are very specific, rare exceptions where the solicitor is actually allowed to speak.
Okay, thank goodness.
The primary one that addresses your nightmare scenario is human safety. Ethics prioritize life over professional secrecy.
So you can intervene.
Yes. Disclosure is justified to prevent a serious criminal offense that would cause serious bodily harm. It is also justified to prevent a client's suicide or serious self-harm, or to protect a child or a vulnerable adult.
The framework basically recognizes that preserving human life outranks everything else.
Absolutely.
Okay, so imminent physical danger breaks the seal. What else?
Informed consent is the most common one. If the client understands the implications and explicitly says, you can share this information, then you can.
Makes sense. Their secret, their choice.
Exactly. Another exception is when the law explicitly requires it, like a direct court order from a judge, or a statutory duty to report money laundering.
Because you cannot use client confidentiality to defy direct legal mandate?
Right. You can't just say, sorry, judge, my lips are sealed.
Yeah, that wouldn't fly. And I assume this also applies if a client is trying to use you to break the law.
Correct. The crime or fraud exception. Professional privilege does not exist to serve as a shield for illegal acts.
So I can't hire you to help me rob a bank.
No. You cannot hire a lawyer to help you orchestrate a bank heist or a corporate fraud scheme and then expect them to keep quiet about it under the guise of confidentiality.
Okay, so we have the firm boundaries of keeping information in and the rare exceptions for letting it out. But the sources highlight another duty that completely flips this dynamic on its head.
Oh, the duty to disclose.
Yes. Here's where it gets really interesting. Solicitors owe an active duty to disclose material information to their own client.
It is the absolute inverse of confidentiality, and it creates a profound tension for the lawyer.
The sources outline this amazing dinner party dilemma. Imagine a solicitor is at a dinner party, totally off the clock.
Having a nice glass of wine.
Right. And they overhear some juicy gossip from across the table. But, plot twist, that gossip is genuinely material to their client's ongoing case. According to the rules, they generally must tell their client what they heard.
They do.
I just don't understand how you navigate that. So you can't be a passive bystander. Your brain essentially belongs to your client's case.
It really does. If you become aware of information that is material to the retainer, meaning it's relevant to the specific legal work you are doing for them, you have to share it.
Wow.
It doesn't matter if you heard it in the boardroom or just standing in line at the grocery store.
It's like trying to play a game of chess where you're forced to actively show your opponent half your pieces while being legally threatened to keep the other half completely invisible. That sounds exhausting.
It is a delicate, high-wire act. You are rigidly withholding information from the entire world to honor confidentiality,
While simultaneously being compelled to actively dump every relevant accidental discovery right into your client's lap.
to honor the duty of disclosure. Exactly.
Playing that chess game with one client is hard enough. What happens when you have a whole firm trying to play thousands of games at once and the boards start overlapping?
It gets very messy, very quickly.
Let's look at a classic SQE scenario from our sources. A brand new client walks through the door, and they want your firm to act against one of your former clients.
A classic conflict.
You want the case, right? But your firm still holds all the deep, dark secrets of the person you are now being asked to sue. How on earth does a firm handle that?
This is the ultimate stress test of those conflicting duties. If we connect this to the bigger picture, the rule is that you can only accept this new client if there is absolutely no real risk of disclosure of the former client's confidential information.
No real risk. That sounds like an incredibly high bar to clear.
It's massively high.
How do you actually prove that in reality?
You have to build what are essentially digital and physical bulkheads within the firm. The lawyers suing the former client cannot be the same lawyers who represented them.
Okay, that seems obvious.
But it goes much deeper than just different personnel. We're talking about completely partitioned computer servers where one team physically cannot access the other's files.
Oh, wow.
Yeah. Separate physical office spaces, restricted keycard access, and sworn undertakings not to discuss the case.
And if you're a smaller firm, like what if you don't have the IT budget to build separate firewalled servers.
Then you simply cannot meet the no real risk standard. In that case, the only alternative is to go to the former client and get their informed written consent to proceed.
Which, let's be honest, asking your former client, hey, can we use our firm's resources to sue you, is going to be a tough sell.
Almost impossible. And if you cannot get that consent and you cannot guarantee those airtight bulkheads, well, the firm must turn the new client away.
The ghost of the former client's confidentiality basically vetoes the new business.
Exactly.
But setting up these digital bulkheads inside a firm assumes the danger is internal. What happens when the threat is just human clumsiness pushing information outside the firm entirely?
The external leak.
I have to ask about the ultimate modern data disaster from the sources. You type out an email full of highly confidential client strategy.
Oh, no.
You hit send, and then your stomach drops because you realize autofill, put in the wrong email address. You just sent your client's secrets to a total stranger.
It is the moment literally every professional dreads.
If you are listening to this and thinking, I would absolutely just hit unsend, close my laptop, and pray nobody saw it, you are not alone. That is raw human instinct.
Of course it is.
But doing that as a solicitor will end your career, won't it?
It absolutely will, because trying to hide the mistake usually makes it catastrophically worse. The regulatory framework anticipates this instinct to cover up, which is why it enforces a strict mechanical 3-step protocol to strip the ego out of the situation.
What are the steps?
Step 1, contact the accidental recipient immediately and ask them to delete or return the information unread.
Okay, damage control.
Right. Step 2, you cannot handle this alone. You must report the incident internally to the firm's COLP.
The COLP.
It stands for the Compliance Officer for Legal Practice. Every firm must designate one. They are basically the internal ethics watchdog.
Okay, so step 2 forces you to tell your boss you messed up.
Yes.
What's step 3?
Step 3 is the hardest one. Inform the client.
Ouch.
You have to tell them their secrets were exposed. This protocol exists because transparency outranks your professional pride. The client has a fundamental right to know their position might be compromised, so they can decide how to proceed.
Notice how every step of that protocol is designed to address a power imbalance. Left to their own devices, a lawyer has the power to just bury their mistakes. The rules artificially strip that power away.
They have to.
And it seems like this concept of managing the power imbalance between the solicitor, the client, and the public is the real driving force behind Section 4 of our sources, keeping the house in order.
That is exactly the right lens to view this through. The legal profession holds immense power, so the rules have to aggressively police how that power is maintained.
Right.
And that starts with the regulator, which in the UK is the SRA, the Solicitors Regulation Authority.
And sometimes policing that power means telling on yourself. The sources explicitly say solicitors must report themselves to the SRA for certain things.
Yes. Significant personal or professional failures.
Like what?
Becoming insolvent, for example. Being charged with a criminal offense, or even just receiving a police caution. You also have an affirmative duty to self-report if you realize that information you previously gave to the SRA is now inaccurate or misleading.
Because the regulator cannot effectively protect the public if they are relying on rumors to find out a lawyer is in deep financial or legal trouble.
Exactly. They need to know immediately.
But what if it's not you? What if you discover a senior partner at your firm is secretly dipping into client funds? Do you just keep your head down?
You cannot. The rules outline a very clear chain of command for reporting others.
How does that work?
If another solicitor commits a serious regulatory breach, you normally report it to your firm's COLP first. It centralizes the reporting and ensures the firm handles it professionally with the SRA.
Wait, let's inject some friction here. What if the COLP sweeps it under the rug?
Oh, right.
What if they say, look, that partner brings in $10 million a year, we are not reporting this, drop it. Are you off the hook because you told the designated officer?
This is where the individual ethical burden kicks back in. If you know the COLP is not going to report it, then you are legally required to report it directly to the SRA yourself.
Seriously?
Yes. You cannot hide behind the firm's inaction. You are an officer of the legal system first and an employee of your firm second.
That is heavy. It takes real courage to do that.
It does.
Now, let's shift from the regulator back to the everyday power imbalance between the lawyer and the client. The sources cover practical rules for client care that artificially tilt the leverage back to the consumer. Let's start with complaints.
Good place to start. Every firm must have a written complaints procedure, and you, as the client, must receive details of that procedure in writing right at the beginning of the retainer.
So before they even start working for you, they have to tell you exactly how to hold them accountable.
Precisely.
And if a complaint is made, they have to investigate it promptly, fairly, and completely free of charge. They cannot bill you for the hours they spend investigating your complaint against them.
Did you imagine?
It would be terrible.
And the rules take it a step further to protect the client systematically. There is a ticking clock.
Tell me about the clock.
If the complaint isn't resolved to the client's satisfaction within 8 weeks, the firm must proactively tell the client about their right to take the issue to the legal ombudsman.
How does the legal ombudsman work?
They are an independent body that handles service complaints. By forcing the firm to tell the client about this external option, the rules prevent the firm from just stalling a frustrated client indefinitely until they give up.
That makes a ton of sense.
Yeah.
Now, what about the money? Because legal fees are notoriously opaque and terrifying for the average person.
Which is why the rules target costs information and what the sources call the VET trap.
The VET trap.
Right from the start, solicitors must give you the best possible information about costs, not just throwing an hourly rate at you, but providing an estimate of the likely overall cost. And if those costs change significantly, they have to update you.
And the exam point our sources highlighted about VAT is wild.
It really is.
For those unaware, VAT is the value-added tax. If a firm forgets to put VAT in the initial client care letter, they generally cannot just quietly add it on to the final bill later. They have to eat that cost.
They do.
Why is the rule so unforgiving?
Because the SRA recognizes that consumers make financial decisions based on the total number they are giving. If a lawyer quotes £1,000, the client budgets £1,000.
Adding a 20% tax shock at the very end abuses the client's reliance on the lawyer's expertise.
Exactly. The rule forces absolute precision up front.
This philosophy of leveling the financial playing field extends to advertising and website transparency, too.
It does. Solicitors can advertise broadly, like in newspapers, social media, leaflets, but there is a massive red line.
No unsolicited, targeted approaches.
None.
So if someone has just been in a devastating car accident, a solicitor cannot immediately contact them out of the blue offering services.
Exactly. Why? Because a person in that situation is deeply vulnerable. They are in pain. They're maybe facing financial ruin. The power dynamic is completely skewed.
The SRA considers that intrusive and exploitative.
Right. They can broadly advertise, but they must wait for the consumer to come to them.
And to help consumers make that choice, there are strict transparency rules for websites, specifically for certain types of services. The sources mention probate, which is the legal process of handling someone's estate after they die, and residential conveyancing, the legal side of buying and selling a house.
Very common tasks.
Firms have to put pricing for these right on their websites. Why these specific services?
Because they are highly commoditized, everyday legal issues, where the consumers are often individuals, not giant corporations. People going through a divorce, buying a house, or dealing with a death in the family need to be able to compare prices easily.
Without having to sit through a high-pressure sales pitch in a lawyer's office.
Exactly.
Demystifying the cost of justice. I love it. Now, there's one final rule from our sources regarding client care, and it perfectly encapsulates everything we've talked about regarding power. The anti-gag rule.
Oh, this is a classic ethics scenario that frequently catches out junior lawyers who just want to make a problem go away.
So imagine a client is furious, they filed a complaint, and the firm says, okay, we'll settle this. We will give you a full refund, plus extra for your trouble. But in the settlement agreement, you have to promise not to report this issue to the SRA.
Which is tempting for both sides.
The rule says that is completely forbidden. Why can't two consenting adults agree to that?
Because a solicitor cannot stop someone from reporting concerns to the SRA or the legal ombudsman. You cannot buy a client's silence when it comes to regulatory matters.
It's about protecting the system.
Think about why this rule exists. If firms could just use their deeper pockets to pay off angry clients and enforce gag clauses, the SRA would be flying blind.
They would only ever catch the incompetent lawyers who couldn't afford to pay settlement.
Exactly. The wealthy, unethical lawyers would operate forever in the shadows. Those reporting rights must always remain untouchable to protect the public.
So if we take a step back from all this, from the invisible bulkheads, the dinner party dilemmas, the data disasters, and the anti-gag rules, what is the actual philosophy tying this all together?
Our sources synthesize it beautifully at the end. Being an ethical solicitor isn't about memorizing dozens of isolated rules. It is about understanding that you serve 5 distinct masters simultaneously.
5 masters.
You must act honestly. You must act independently. You must protect your client. You must protect the public. And you must protect the administration of justice. Every single rule we've explored today is just a practical mechanism for balancing those 5 duties when they collide.
It is an incredible balancing act, ensuring the lawyer remains a trusted confidant without becoming an enabler of harm.
It really is.
Which brings us to a final thought for you to ponder. We've learned today that confidentiality outlives the client, continuing even after they have passed away. But we've also learned that rare exceptions exist to prevent serious, imminent physical harm.
Right.
So imagine a scenario where a deceased client's closely guarded secrets hold the only key to preventing a catastrophic future harm to the public, maybe an environmental disaster they secretly set in motion years ago.
That's a chilling thought.
If the client is gone, but the danger is slowly approaching, how will future legal frameworks weigh the ghost of confidentiality against the survival of the living? Do the walls of that invisible trust remain intact forever, or does human safety eventually demand that we unlock the vault one last time? Thank you for joining us on this deep dive. Keep questioning the invisible rules that hold our society together, and we will see you next time.